just a couple of quick opening remarks while we watch additional people join in. It looks like we're up to about 35 participants at this point, in addition to the panel. And we had outstanding signups this time. We've got upwards of 80 people, it looks like, planning to join us. And what I find truly interesting is the array of audience members. We've got people from family foundations, arts organizations. There's quite a few of those in the audience. A lot of active charities doing both social justice work, legal aid, research institutes. We've got a number of nature organizations, and then a number of professional advisors. There's quite a few lawyers on the line. This does have MCLE credit for lawyers, and I believe we have accountant credit as well. I'll have to check with Margaret on that, but we usually do for continuing ed. And then I see some of our financial advisors and other nonprofit consultants that are joining us today. So welcome to you all. It's just amazing to see this kind of turnout. Some of you may recall that I don't know how many of you will, but I started this series for nonprofits. I think it was about 26 or 27 years ago, not quite 30 years now. And so it's just personally very gratifying to see that we continue to attract nonprofits to come and have these conversations. I miss the old days when we did this in person with wine and cheese afterwards, but maybe we'll be able to do a combination of that and continue webinars in the future. So one other plug, in addition to the real estate program in March, April will be another version of my seminar for nonprofits for lobbying and electioneering activities in an election year, because here we are again in yet another election year. So I don't know if we have a date for that one yet, but that'll be coming up in April. So with that, I think the last thing I want to request is that for those of you, I see there's many first timers. If there are particular topics that you'd like to see in the future, please be sure to note that on the evaluation form, which we will be sending after the conclusion of the seminar. I'd love to hear topics that this audience wants to hear more about. We routinely do employment, real estate, insurance, and a few other topics that are of interest to the nonprofits. But if there's something else, please let us know. We're happy to provide the kinds of content that people want to hear about. So with that, I will turn it over to Chandra and Rebecca to introduce themselves and get us started in learning what we need to know about employment laws this year.
Thank you, Cynthia, and welcome everybody to our presentation this afternoon. I am Chandra Andrade, and I'm a partner in Frella's employment practice, and I spend most of my time advising clients on the management side about maintaining and implementing compliant workplace policies, as well as defending employers in connection with civil and pre-litigation type demand letters, as well as arbitrations and civil actions.
And good afternoon, everyone. I'm Rebecca Stevens. I'm a colleague of Chandra's in the employment practice group here at Frella, and my practice is similar to hers. It's a mixture of representing and advising employers in California, federal law, and all sorts of issues that arise there. So welcome. We're excited to have you here today.
So here we just want to let you know about what we're going to be covering today. So it's kind of two parts to our presentation. First, legislative and judicial changes that came out of the legislative session last year, and most of which changes took effect in January of 2022. And so we'll cover template employment document updates, as well as some changes to the California Family Rights Act, updates to the DFEH mediation program, some new guidance around personnel records and notices, and then some minimum wage updates. And then after that, we'll turn to a segment on what many people are worried about these days, which is COVID-19 requirements and best practices, which is a very much moving target with some new regulatory guidance issued just yesterday.
Okay, so next slide, please, Margaret. So just to give you a quick overview of this next section, we'll be talking about some changes to the law that may require all of you to review your template employment documents. There have been some changes to requirements for settlement agreements related to employment claims. There's also been some changes to requirements for separation agreements for departing employees. And then also some limitations on arbitration agreements and some updates about litigation that's been going on there. So all of these new issues actually relate to the Me Too movement that has been going on, which seems for years now. We are continuing to see new legislative updates, new legislative issues that are still coming out of that. So we'll turn to the specifics just now. Next slide. So just as a reminder of the existing law, which was passed a couple of years ago, effective January 1st, 2019, there was a change in law that prevented confidentiality provisions in settlement agreements that would prevent the employee from disclosing factual information relating to a claim of sexual assault, sexual harassment, workplace harassment, or discrimination based on sex, and retaliation for reporting harassment or discrimination based on sex. So as you can see, this existing law really came out of the Me Too movement, and it was coming from a place where employees who had been the victims of these types of issues in the workplace were feeling like they wanted, even when they settled a claim with their employer, they wanted to be able to share the information later. They didn't want to be bound by these confidentiality agreements. Next slide. The update this year is that prohibition has been expanded beyond the sex discrimination and sexual harassment context. And now when you're dealing with a settlement agreement for any claim that's been filed in court or with an agency, you can no longer have a confidentiality provision that would prevent the employee from sharing factual information relating to any type of claim of workplace harassment or any type of claim of workplace discrimination. In addition, you can no longer prevent the employee from sharing factual information about any type of claim of retaliation for reporting harassment or discrimination based on any protected characteristic. So obviously this is a big change. One of the main benefits to settlement that most employers have enjoyed for a long time is that confidentiality. You don't want the details of every dispute that you had with an employee to later become public, particularly if you've spent a lot of money to settle the claim. Unfortunately, given this change in law, once a claim has been filed in court or with an agency or an arbitration, and it's a claim of discrimination, harassment, or retaliation, you're no longer allowed to have a confidentiality provision that would prevent the employee from discussing those underlying facts. Next slide. In addition, existing law, which came into effect January 1st, 2019, this law previously and already prohibited employers from requiring employees to sign agreements in connection with a raise, a bonus, or continued employment. You couldn't have the employee sign an agreement that would release FEHA claims, Fair Employment and Housing Act claims. You couldn't have an agreement that would prevent the employee from disclosing information about unlawful acts in the workplace. And you couldn't have the employee sign a statement that they don't possess any claims or injuries against the employer. So it used to be fairly common practice that when an employee was getting a raise, getting a bonus, or a promotion, the employer might ask them to sign this type of agreement in connection with that. And as of 2019, that was no longer permitted. Next slide. This year, there's been an expansion of that law. And now, in addition to the agreements that we just talked about on the last slide, there's new limitations relating to confidentiality terms in separation agreements. So if you're having an employee that's departing, you're offering a severance agreement to that employee. Employers typically want to have some kind of confidentiality provision that says, okay, we're offering you this severance payment. In exchange, you're releasing all claims, and you're also agreeing to keep all the things that happened during your employment confidential. This new law says that if you have a separation agreement with an employee that has a non-disparagement provision, you have to include a carve-out that states nothing in this agreement prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or any other conduct that you believe is unlawful. So one thing that jumps out to me off the bat is how broad this carve out actually is, because unlike the prior statute that we discussed, which was really limited to harassment, discrimination, and retaliation, this carve out allows employees to share information about any conduct that they believe is unlawful. It doesn't have to be something that actually is unlawful. So this is a pretty broad carve out. And again, this is kind of designed to tamp down on employers, forcing employees to sign these NDAs, non-disparagement provisions that would prevent them from later disclosing information about things that had happened in the workplace that were unlawful. Next slide. In addition, this statute also requires that any separation agreement state that the employee has the right to consult an attorney about the agreement and offer a reasonable time of at least 5 business days to consult with the attorney. The employee can decide to sign earlier than the 5 business days. They don't have to take the full amount of time, but it has to be a knowing and voluntary decision on the part of the employee to do so, and the employer cannot put any pressure on the employee to do that. The law is clear that you can still require the confidentiality of the payment amount in the separation agreement, and you can still have provisions that would protect trade secrets, proprietary information, or confidential information that does not involve unlawful acts in the workplace. Next slide. So the key takeaways from these 2 new laws, separation and settlement agreements can still require the confidentiality of the payment amount, but keep in mind that there was also a federal law that changed a couple of years ago that prohibits a tax deduction for a sexual harassment settlement payment if it's required to be kept confidential. In my experience, most employers would rather have that confidentiality, so they're willing to forego the tax deduction of that settlement payment, but it's something that has to be considered on a case-by-case basis, and of course, consulting with counsel and tax professionals about the implications of that. As I hope was clear from the last few slides, there are now severe limitations on the confidentiality of information relating to unlawful conduct in the workplace. So if you're talking about a settlement agreement of a filed claim or a filed administrative charge, you cannot have any provision that would require the confidentiality of facts that underlie a claim of sexual assault, harassment, discrimination, or retaliation. And if you're talking about an agreement that's in connection with a raise, a bonus, a separation from employment, or as a condition of employment or continued employment, you cannot have a non-disparagement provision that would prevent the employee from sharing information about unlawful acts in the workplace, including acts that the employee believes is unlawful. There is still kind of an open question about whether you can have these confidentiality provisions in a settlement agreement of a claim that has not yet been filed in court or before an agency. So the provision that deals with settlement agreements is quite clear that it only applies to something that's been filed, but the provision that deals with agreements that are related to an employee's separation from employment, we've already had plaintiffs' counsel arguing that a settlement of a demand letter, something that hasn't been filed, if it alleges wrongful termination, then it is an agreement related to the employee's separation from employment and would therefore fall under this statute that limits confidentiality. I think there are some arguments to the contrary, but just kind of a heads up that that remains an open question and is probably something that's going to require further clarification either by the legislature or in the courts. Next slide. In addition, there's a few updates on arbitration agreements. Some of you may recall that there was a law passed a couple of years ago that was supposed to take effect in 2020 that banned mandatory arbitration as a condition of employment, continued employment, or the receipt of an employment-related benefit. That was a California statute that was passed a couple of years ago. Before that law really took effect, the U.S. Chamber of Commerce challenged that law in federal court, arguing that it conflicted with the Federal Arbitration Act, which is a federal statute that states a broad public policy of the enforceability of arbitration agreements. The U.S. District Court that was hearing the case agreed with the Chamber of Commerce that there was likely to be a conflict between federal and state law on this issue, and it issued an injunction that prevented the California law from taking effect. So that ban did not go into effect because of that injunction. In September of 2021, the Ninth Circuit reversed the district court and found that the California law did not conflict with federal law because that law was really focused on the formation of arbitration agreements and whether the arbitration agreement is actually voluntary on the part of the employee rather than mandatory and forced on them by the employer. And so the Ninth Circuit panel indicated that it would allow that California law to take effect because it didn't find any conflict between the two. The U.S. Chamber of Commerce has requested an en banc hearing by the Ninth Circuit, which means they're asking the full Ninth Circuit to rehear the case and hopefully reinstate that lower court injunction. In the meantime, the decision in joining the enforcement of the law does remain in effect, so the law hasn't taken effect yet, and litigation is definitely expected to continue, including potential U.S. Supreme Court review. So given the uncertainty as to whether this California law is ever going to go into effect, we've seen employers take a variety of approaches. Some employers have decided to just do away with arbitration agreements in their entirety. Some employers have decided to continue requiring mandatory arbitration, risking that this law will someday go into effect and potentially invalidate all of the arbitration agreements that were entered during the time after the law was passed, and there may be some civil penalties associated with that. And then some employers have decided to modify their arbitration agreements to make them voluntary because the ban was only on mandatory arbitration. Voluntary arbitration agreements are still allowed. Obviously, the risk there is that you may have employees that refuse to sign the arbitration agreement, or you may have some employees that do sign and some that don't, which could create, some administrative problems in the workplace. So I think there's still a lot to come here, but it's still a very influx area. Next. And then hot off the presses, just a week ago, the US Congress passed a bill that will ban companies from forcing employees to arbitrate claims of sexual assault or sexual harassment. President Biden has not yet signed the bill into law, but he is expected to do so. And what will happen when the law goes into effect is that any existing arbitration agreement or any new arbitration agreement will be basically null as applied to sexual assault and sexual harassment claims, and employees who have signed arbitration agreements will still be able to file those sexual assault and sexual harassment claims in court, notwithstanding the arbitration agreement. There's still some open questions here. For example, if you have an employee that's alleging multiple types of claims, a sexual harassment claim, maybe a race discrimination claim, maybe some unpaid wage claims, it's not clear what would happen there if all of those claims would now be allowed to proceed in court because there's a sexual harassment claim, or if some of them would stay in arbitration or some would be in court. None of that is clear yet because this law is, brand new and actually hasn't even taken effect. Next. And then just a couple of quick updates on the payment of arbitration fees and costs. As you may know, there was a law passed a couple of years ago that requires the drafter of an arbitration agreement to pay all of the required fees and costs within 30 days after the due date, or else the party would be in breach of the arbitration agreement, which would then allow the case to go into court. So that remains in effect. And next. And kind of following up on that law, there's a new law this year which requires arbitration providers to immediately provide an invoice for the arbitration fees once the requirements to initiate the arbitration have been met. And the provider cannot provide an extension on the payment deadline unless all the parties agree. Next. Okay.
So as most of you are aware, the California Family Rights Act provides 12 work weeks of job protected time off in any 12-month period if an employee needs the time off to bond with a new child, to attend to their own serious medical condition, or care for a close relative with a serious medical condition. And as of a legislative change from a couple years ago, private employers with fewer than 5 employees are exempt. But now employers with 5 or more employees do have to comply with the CFRA. In 2020, another prior Senate bill had expanded the list of relatives whom employees can take time off to care for under CFRA. And that bill had left some confusion about whether employers must provide employees job protected CFRA time off to care for a parent-in-law with a serious health condition. And so this bill, AB 1033, clarifies that employees do in fact have the ability to take CFRA leave to care for a parent-in-law. We did want to point out that there were a couple of other bills last year that were up for signature or were in the Senate and they didn't actually pass. And so one of those would have expanded this list of relatives to actually include a designated individual, whether or not a relative. So somebody, perhaps a live-in boyfriend or girlfriend, and that bill did not pass. I should say it was pulled before the final vote. And then another bill would have increased wage replacement rates for the paid family leave benefits, another sort of related state benefit that employees of different size employers are entitled to take. And so that one was also vetoed by Governor Newsom. So no need to worry about that for this year. Next. So AB 1033 updates a sort of unique legislative idea here that came out from another legislative session another couple of years ago, this DFEH mediation program for small employers. And so existing law had required the Department of Fair Employment and Housing to create a small employer family leave mediation program for alleged violations of family care and medical leave provisions. And so this program was applicable to employers with between 5 and 19 employees. So I suspect a lot of the folks who are on this call come from organizations of that size, which is why we're including this. And so what basically AB 1033 does is it requires the DFEH, when an employee requests an immediate right to sue alleging a violation of one of these leave acts, to notify the employee in writing of the requirement for mediation under this pilot program before they can go ahead and file a civil action. And that's if mediation is requested by either party, the employer or the employee. So ultimately what this bill does is really encouraging employees or former employees of smaller employers to try to resolve disputes in a much more cost-effective, oftentimes more efficient venue, this mediation program at the Department of Fair Employment and Housing, instead of sort of filling up the courts with these disputes in an actual civil litigation. Next. So some other laws that are kind of administrative in nature, but we did want to point out here for you, particularly for UHR folks, is as you all are probably aware, there are requirements in various places of the labor code and other California laws that require employers to post essentially posters of the wage rights and other rights that employees have. And so those posters are required to be prominently displayed at the work site. And so what SB 657 does is authorize employers to distribute these required notices to employees by electronic means, specifically by email, just attaching these notices. The sort of frustrating thing about this is this bill doesn't obviate the need to still display the posters physically at the workplace. It's just another means that employers can use to make sure employees are aware of these rights. So continue to post your workplace postings prominently at the work site, but especially for those employees who are now primarily or hybridly working remotely, it's a good idea to take advantage of this provision and send them those notifications by email as well. Another administrative change in the law as of January is SB 807, which extends the time period within which employers have to retain personnel records for their employees and applicants. It used to be 2 years, and now it's 4 years from the date the records were initially created or received, or from the date any employment action was taken. So it's just a reminder here, best practice is to keep your employment records, I would say, for at a minimum of 4 years. Ideally, you could keep it even for more than that, because oftentimes these records can become very helpful in litigation that might come up over time. But here, just be aware that if you have automatic deletion or any other sort of document preservation policies that followed the prior 2-year limitation period, make sure that those are expanded accordingly to the 4 years. Next, please. So minimum wage workers, minimum wage for workers with disabilities. This gets to a sort of unknown law that actually had come from an outdated federal policy that dates back to 1938, which allowed employers who secured a certain certificate to pay people with disabilities underneath the minimum wage. The number of employers in California who've been seeking these kinds of certificates has continued to drop over time, but the practice still remains legal. And so what SB 639 does is prohibits any such licenses from being issued and then phases out licenses over the course of 3 years. And so ultimately by January 1st, 2025, it will be illegal to pay an employee with disabilities less than the minimum wage, regardless of license status. So especially for nonprofits, some of you may have taken advantage of these licenses. Just be aware that that is not going to be permissible within 3 years. Minimum wage updates here, just a reminder that effective January 1st, employers with 25 or fewer employees have now a minimum wage rate of $14 an hour. And then for larger employees of 26 or more, that minimum wage is $15 an hour, and that's statewide. We want to point out especially that this minimum wage increase also affects the minimum salary with which you can classify employees as exempt as opposed to hourly. And so employers with 25 or fewer employees now can only classify people as exempt if that person is earning at least $58,240 a year. And then for larger employees, that threshold is $62,400. I think, as all of you know by now, the requirement to classify folks as exempt has various components. That salary threshold that's at issue here is just one piece of it. There's also duties requirements and then a couple of other analyses that have to happen before you can classify somebody as exempt, but certainly these salary thresholds are the first place to start. And here we just also want to remind you that various cities have their own minimum wage rates, and those have also been going up over different times. Some go up in July, some go up in the beginning of the year. So these are the current minimum wage rates in different localities, and you have to make sure that you're applying the minimum wage rate that applies to the city that you're in. And if there's no city-specific minimum wage, you need to refer to the California state minimum wage on the previous slide. AB 1003 is a new law that really underscores California, particularly this particular state's continued intense focus on the proper payment of wages to employees. So everyone who employs people in California knows that it's a pretty strict state to be in, and it's hard to comply with all the thicket of wage requirements. And what AB 1003 does is really drive that home by saying that the intentional theft of wages, including gratuities in an amount greater than $950 from any one employee, or $2,350 in the aggregate from 2 or more employees in any consecutive 1-year period, is punishable actually by grand theft. And so this adds a section to the California Penal Code and provides for criminal penalties against employers that intentionally withhold compensation from their employees. I should add that this law, AB 1003, defines employee to include independent contractors. So it's another reason you need to make sure that you're properly paying your independent contractors what their agreements specify they are to be paid. And of course, also to make sure the classification of independent contractor is correct, which is always a tricky area. Always good to engage legal counsel before you classify folks as independent contractors, as we've seen happen all too much.
Okay, turning to the topic that you're probably all very interested in, the never-ending pandemic that we're in and the never-ending changing rules and requirements. So next slide, Margaret. We've been getting lots of questions from clients, off the bat as to, which rules apply. What are the rules that apply to different types of businesses, different sizes of organizations? Just to start us off, Cal OSHA has issued emergency temporary standards, which remain in effect for all employers with only a few exceptions. And the exceptions are work locations where there's only one employee that does not have contact with other people, employees who are working from home, employees working from a location chosen by the employee that is not under the control of the employer. So for example, if they're working from a cafe or from a library or something like that. And then employees that are covered by aerosol transmissible diseases regulations, which are mostly for employers in the medical industry, hospitals and things like that, where they have their own requirements that differ from everybody else's requirements. In addition to the Cal OSHA emergency temporary standards, employers also have to follow the California Department of Public Health orders, which come out, which I'm sure many of you know sometimes conflict with the Cal OSHA guidance. And then on top of that, we layer in the county and city guidance that comes out that employers also have to stay on top of, which sometimes conflicts with all of these other rules as well. So lots of things to stay on top of. The general guideline when there are conflicts is to go with the rule that's the most protective of the employees, because that's pretty much the public policy of the state. When you have different laws in place, whichever one protects the employees the most is the one that needs to be applied. Next slide. So hopefully all of you are aware that if you have employees that are coming to work in a physical location, in an office, or any other site, a COVID-19 prevention program is required, and that's been a requirement for several months. So if you don't have one yet, it's something to definitely make sure you take care of promptly. The written COVID-19 prevention program has to address all of the elements that are listed on this slide, which are numerous and detailed. You have to communicate to employees about the employer's COVID-19 prevention procedures. You have to include an explanation of how the employer will identify, evaluate, and correct COVID-19 hazards in the workplace. The employer has to require and provide face coverings and respirators as specified in Cal OSHA standards. The plan has to advise employees that they are allowed to wear masks at work, regardless of their vaccination status, and that retaliation against employees that voluntarily choose to wear face coverings is illegal. The plan also has to address some really nitty-gritty stuff about engineering controls, administrative controls, and PPE. So information about ventilation and things like that has to be incorporated into the plan. The plan also has to articulate procedures for investigating and responding to COVID-19 cases in the workplace. The standards require that employers provide COVID-19 training to employees. Cal OSHA said that it would be making some compliant trainings available online, but I checked this week and they're not there yet. So not super helpful for all of us that are required to comply in the interim. Employers are required to make testing available at no cost to employees who've had a close contact with COVID in the workplace, or for situations where there's been multiple infections or an outbreak in the workplace, the employer has to make free testing available on a regular basis for employees who've been exposed. The employer has to have a plan to exclude from the workplace employees who have positive COVID-19 results and employees who've had close contact with others who've tested positive. You have to follow the return to work criteria that's been put in place by the Department of Public Health and Cal OSHA. And then employers are also required to maintain records of COVID-19 cases and report serious illnesses. So as you can see, there's a lot to think about, a lot of information. There is a model COVID-19 prevention program available online through Cal OSHA, and most of our clients have chosen to at least use that as a starting point because it helps you get organized and think about your thoughts. I do see a question in the chat which says, is there a specific employer size for the program? And unfortunately, there is not. If you have more than one employee that's reporting to work, all employers are required to have this plan. Next slide. There have also been a couple of revisions recently to the COVID-19 standards. Interestingly enough, the definition of a COVID-19 test, it used to say that only a PCR test would be acceptable for the times that testing was required. But now the new standards allow for workers to do a test at home with self-read results. However, the interesting piece about this is that the employer or a telehealth professional has to observe the use of the test. So you may have to have somebody get on Zoom with the employee to watch them take it, which for many employers is probably not something you want to have your staff getting involved in. So you might just want to stick with the PCR test instead of this option. The definition of face coverings has also been updated to include more detail about the different types that are acceptable. The definition of fully vaccinated has now also been updated to address the minimum time that employees need to wait between the first and second dose of a 2-dose vaccine. Interestingly, the testing requirements have been updated. It used to be that only unvaccinated employees had to be provided testing after a close contact in the workplace. But under the new testing standards, testing has to be made available to even vaccinated employees that have a close contact in the workplace. So that's a pretty significant change. And then during an outbreak, which is defined as 3 or more positive cases in the same site within a 14-day span, COVID-19 testing has to be made available to all employees, regardless of vaccination status, on a weekly basis or twice per week during a major outbreak. And then lastly, the face covering requirement has been extended to require fully vaccinated employees to have to wear face coverings if they're in transportation provided by the employer. Next slide. The Cal-OSHA guidance on face coverings is that employees who are not vaccinated have to be provided with face coverings, and the employer has to ensure that they're worn over the nose and mouth when they're indoors and in vehicles. Outdoors, no employees need to use face coverings regardless of vaccination status unless there's an outbreak. And then employers also have to provide and ensure the use of face coverings by employees when the California Department of Public Health is requiring it, when an employee had COVID-19 or had close contact with a COVID-19 case and returns to work, or when riding an employer-provided motor vehicle transportation. Next slide. The exceptions to the face covering requirement are when the employee is alone in a room or a vehicle, when the employee is eating or drinking, so long as they're 6 feet apart from other employees or outside. Employees that are wearing respirators don't have to wear additional face coverings. And then employees who can't wear face coverings due to a medical or mental health condition or disability because they're hearing impaired or communicating with a hearing impaired person, or when they're performing specific tasks that cannot be performed while wearing a face covering. And then employers do also have to provide face coverings to employees upon request, regardless of vaccination status. So even vaccinated employees can ask for and must be provided with face coverings. Next slide. Now, the California Department of Health guidance has changed effective yesterday, as you may all know. So it used to be that everyone was required to wear masks indoors under the state Department of Public Health order. As of yesterday, that requirement has been lifted. And so universal masking is only required in certain specified settings. As of yesterday, only unvaccinated individuals have to wear masks in all indoor public settings and businesses. And then fully vaccinated individuals are recommended to continue indoor masking when the risk may be high. I'll add that employers, of course, are free to require their own employees to wear masks if they want to. You know, that's something that employers are free to do if that's something that you'd like to do. And particularly in public facing settings, that may be something that's desirable. It's just that the California Department of Public Health is no longer requiring that. The masks are required for everybody in the following indoor settings, regardless of vaccination status. So on public transit, indoors in schools and childcare settings, emergency shelters and cooling and heating centers, healthcare settings, state and local correctional facilities and detention centers, homeless shelters, and long-term care settings and adult and senior care facilities. These are all places where masks are still required regardless of vaccination status. I'm seeing a couple questions about specific settings, like elevators. Again, there's no specific guidance from the Department of Public Health about that, but of course, employers are free to say, we're going to require everybody to wear masks in elevators regardless of status. Employers can really set the rules here since the Department of Public Health has lifted its rules. Next. Vaccines. Some of you may have been following the federal rules that have changed in this regard. You may recall that the Biden administration, OSHA, had issued a rule requiring all employers with 100 or more employees to have their employees vaccinated. That rule has been struck down by the US Supreme Court. So there's currently no legal requirement that employers have to mandate vaccination. Employers may require employees to become vaccinated if they choose to, so long as the employer does not discriminate against or harass employees or applicants on the basis of a characteristic, so long as the employer provides reasonable accommodation related to disability or religious beliefs, and so long as the employer does not retaliate against anyone for requesting an accommodation. Employers are also permitted to require employees and applicants to submit proof of vaccination. Next slide. And then when it comes to addressing COVID-19 cases, employers are required to investigate and respond to COVID cases in the workplace by determining when the person was last there, who may have been exposed, and providing written notification to anyone who may have been exposed. But keep in mind that the identity of the person who tested positive, of course, has to be maintained confidentially. And so the notification should really just tell someone, you've potentially been exposed, here's the date, we're providing testing, here's what you're entitled to, et cetera. Next. In addition, the employer has to provide testing for anyone who's been exposed and exclude people who either tested positive or had close contact from the workplace until they're no longer at risk. And then the employer also has to investigate the exposure and whether any workplace conditions could have contributed to the risk and what corrections might help reduce the risk going forward. And as you all may know, a close contact is defined as being within 6 feet of somebody with COVID-19 for a total of 15 minutes or more in any 24-hour period while overlapping with their high exposure period. So the time right around when they first become symptomatic or first test positive. Next slide.
And just to reiterate, responding to a question in the chat, yes, the slides will be provided to you after the program, so no need to absorb and write down all of this information. And by the way, a lot of this information is pretty readily available online at the Cal OSHA website, which changes pretty regularly, and there's fairly well-written FAQs covering a lot of these issues as well. So, so certainly lots of resources, but we're touching here on the kind of key criteria and changes that are impacting all employers in California. So here and for the next couple of slides, I'll talk about isolation and quarantine requirements and the associated timelines when employees can return to work after isolation and quarantine. That's the term is called exclusion under the ETS. And fortunately, as Rebecca had mentioned earlier, there has been sort of conflicting guidance about how long someone has to quarantine, how long someone has to isolate after close contact, et cetera. And the guidance from the ETS had been a little bit contradictory from the California Department of Health. And then you have the federal CDC. And so fortunately, in December of 2020, Governor Newsom had issued an executive order, which basically said that any ETS guidance around quarantine and isolation requirements are necessarily going to be overridden by any applicable recommendations by the California Department of Health if the periods in the ETS standards are longer than those recommended by the Department of Health. So in other words, the Department of Public Health, if they come up with shorter periods for isolation and quarantining than the existing ETS standards, you follow the shorter periods. And fortunately as well, the CDPH has been consistently following the federal CDC in a lot of these areas as well. So in terms of just these isolation and quarantine basics, remember that isolation applies if you're sick or test positive, even if you don't have symptoms, whereas quarantining applies for those who are just exposed to the virus. And so on this slide, you'll see the exclusion from the workplace requirements for employees who must isolate due to a COVID test that was positive or who have symptoms, i.e. isolation. And the kind of gist here is that everyone, regardless of vaccination status, does have to isolate if they test positive. And you can return to work after day 5 if symptoms are not present and there's a negative test. So this requirement used to be 10 days, and so now it's a little bit shorter. It's 5 days for folks to isolate once they have a positive test, and then they also get a negative test before coming back to work. There are additional days that apply if the person's symptomatic after day 5, and or if the employee just decides not to test or is unable to. And then there's also some residual mask wearing requirements for those who come back to work after their isolation period. It's an additional 10 days after the positive test, especially indoors. And then just generally guidance continues to be that if anybody has a fever, they should necessarily stay home until the fever resolves. Even if you're past day 5, you have a negative test, if you have a fever, stay home. Next. So these next 2 slides apply in the case of quarantining. So again, when there is not a positive test and no symptoms, it's more about exposure to someone that does have COVID. And so different, in this context, there's more strict rules that apply to employees who are unvaccinated or those who are vaccinated and booster eligible but have not received their booster dose, as compared to employees who are fully up to date on their vaccinations, which we cover in the next slides. There was a question in the chat about guidance around boosters. This kind of touches on that. Basically, if you're up to date on your vaccinations, the quarantine requirements are a little bit more relaxed than the quarantine requirements for folks that are not up to date. I won't go into much detail here. The information here is there for your consideration, but again, it's exclusion from the workplace for a period of 5 days. And then exposed employees have to test on day 5, and then quarantine can end if there's and the employees may return to the workplace if symptoms are not present. And then an exposed employee who tests positive for COVID-19 after a quarantine period, just remember, once they test positive, then you see slide previous, which is about isolation. So these things can shift in real time. And then, as I mentioned, if you go to the next slide, this covers the more lax requirements I referenced for those who are up to date on their vaccinations. And so these people do not have to actually be excluded from the workplace after an exposure. They just do have to test on day 5 and have a negative result. And once again, if they have a positive result, then you see the first slide in this set. Next slide. So associated with the concept of exclusion from work due to either a positive test or for exposure to somebody else with COVID comes this concept that came out of Cal OSHA of exclusion pay. So Cal OSHA's temporary standards require that employers maintain an employee's pay and benefits while an employee is excluded from the workplace because of a workplace COVID-19 exposure. That's a key criteria there. This is exclusion pay does apply to any size employer, so everybody on the call should be aware of these requirements. And exclusion pay is not required, just to drive home the point, to an employee who is exposed to COVID-19 somewhere outside of work. Like if they're on vacation or they went to a party over the weekend or something, then there's no requirement to pay the exclusion pay. Of course, we see a lot of clients who have some questions about, well, how do I know if the exposure was at work or not? There is some guidance in the ETS standards that address that. There is some ability for employers to require some proof if they have reason to believe that the employee was not exposed at work. And of course, if there's other people who have been exposed, who have shown positive tests at the workplace, that's normally going to create a presumption that the exposure to another employee was at the workplace as well. There's another question we get a lot from clients is if this exclusion pay requirement to essentially give sick leave to people can be kind of applied, or I should say can be satisfied by the use of paid sick leave that was required pre-COVID-19. So in other words, as many of you probably are aware, well before COVID, California has required at least 3 days of paid sick leave to all California employees who work a minimum amount of time in the state. And the answer is that employees that provide a paid sick leave policy that is separate and in addition to the state mandated paid sick leave law may require their employees to use that separate sick leave as permitted by law to satisfy this exclusion pay. But an employer cannot require the employee to use their standard California paid sick leave requirements to satisfy exclusion pay. So to make matters a little bit more confusing, as you may also recall, there's another concept that's come out of the COVID-19 era, which is supplemental paid sick leave. And so in last year in 2021, the Cal OSHA ETS standards and then also the California state legislature had passed a requirement called 2021 COVID-19 supplemental paid sick leave, which required employers for the period from January 1st, 2021 to September 30th, 2021 provide up to 80 hours of paid sick leave to employees who are unable to work or telework for COVID-19 related reasons. I do want to emphasize that supplemental paid sick leave for COVID-19 purposes is only applicable to employers with 26 or more employees. So if you are an employer with 25 or fewer, you don't need to worry about supplemental paid sick leave. There's a couple differences between supplemental paid sick leave and then the exclusion pay that we looked at before. The primary one is that supplemental paid sick leave does not have to be related to an exposure to COVID-19 at the work site. It's any exposure, anytime someone has COVID-19, whatever the source, they can be entitled to use the supplemental paid sick leave. So last week, Governor Newsom approved a measure that revived the statewide supplemental COVID paid sick leave into 2022. And so it now basically says employers now have to provide supplemental sick leave from January 1st, 2022 through September 30th of this year as well. And just to be super clear, this is a supplemental benefit. It has to be in addition to exclusion pay and also in addition to your California mandated paid sick leave that predated COVID. There's a bunch of sort of differences between the 21 supplemental paid sick leave and the 2022 law that I won't go into too much detail, but there is some extra bases for employers to try to mitigate against some of the fraud that we saw over the last year of employees trying to take advantage of supplemental leave when they didn't actually have COVID. They saw 80 hours of time off that was paid and folks were taking the leave without having actually a qualified reason. So there's some mitigation for that in this new version of the law. I did mention the potential recruitment through tax credits. I think that's actually going to come through. It's essentially a different statute that was passed last year, part of the budget reconciliation from the governor. Provides some mechanism for smaller employers to recoup some of these benefits through tax credits. To be honest, I'm not entirely sure what that looks like, but there is a potential for that, and happy to answer questions about that separately if you have specific ones that apply to your business. And then in terms of local COVID-19 ordinances, just also be aware that to make matters even more complicated, some localities have also passed ordinances requiring an additional allotment of supplemental paid sick leave for COVID-19 purposes. So just be aware if you're in any of these 4 cities that there may be additional and even contradictory requirements.
Okay, last couple of points. Thanks for hanging in with us for the past hour. Senate Bill 606 is the last topic that we'll cover today. And it's a bill that was passed to really ramp up Cal OSHA's enforcement abilities and the penalties for employers that violate OSHA standards and OSHA requirements. This is not specifically tied to COVID. I think the pandemic helped get it passed, but it actually applies to all sorts of COVID violations or all sorts of OSHA violations, not just COVID. Next slide. The first thing that SB 606 does, it creates a category of, quote, egregious violations. If any of these criteria on this list are satisfied, then Cal OSHA can find that the employer is guilty of an egregious violation, which leads to additional penalties and perhaps additional enforcement mechanisms. So for example, if the employer intentionally made no effort to remedy an issue, or the violations resulted in a significant number of employees being hospitalized or dying, really serious situations, there's this new category called egregious violations, and there are additional penalties that come with it. Next slide. The other category that was created by this new law is enterprise-wide violations, and that's where there's a rebuttable presumption that a violation by an employer that has multiple sites is enterprise-wide if either of the following is true. So if the employer's written policy or procedure on its face violates the regulations, that's a rebuttable presumption, or if Cal OSHA has evidence that there's been a pattern and practice of the same violation committed at multiple sites. If there is a finding of an enterprise-wide violation and the employer is not able to rebut the presumption, then Cal OSHA can issue an enterprise-wide citation that requires abatement. And the penalties can be up to this very strange and random number of $124,709 per violation. Not sure where they came up with that, but that is the number, and it's pretty stiff. Cal OSHA cannot assess an enterprise-wide violation if the policy is based on an emergency regulation that came through within the last 30 days. So at least there's some acknowledgement by Cal OSHA that given all these changes, all these new things, it's tough for employers to keep up. And so they're not going to be issuing these heightened penalties if the rule that the employer is breaking has only been in effect for 30 days or less. The other thing that SB 606 does is it gives Cal OSHA new tools to issue subpoenas or seek injunctions, just more ability for Cal OSHA to go into court to enforce its rules and get different rulings against the employer. Okay, so we'll stop here and turn to any questions that are left. If you have any questions that haven't been addressed, feel free to add them in the chat. Or we'll hang out for a few minutes if people want to ask the questions live.
And I think this concludes the presentation, right? For our
Yes, the magic word.